In the summer of 2025, something happened at the Supreme Court that almost slipped past most Americans. While cable news chased the latest political drama, 9 Supreme Court justices reached a unanimous decision that will reshape how police interact with citizens for decades to come. And now a new round of cases involving your gun rights and your privacy is sitting on the court's docket, waiting to be decided. If you own a firearm, if you've ever been pulled over by police, or if you simply care about what the government can and cannot do to you, what happens in these courtrooms over the next few months will directly affect your life. By the end of this video, you will understand exactly what the Supreme Court has decided, why it matters to every American, and what to watch for in the coming months as these cases move forward. This is not abstract legal theory. This is about the rights written on paper that protect you in the real world, and whether those rights actually mean something when the moment of truth arrives. Let's start with the case that already happened, because it set the stage for everything that is coming. In May 2025, the Supreme Court issued a rare unanimous ruling in a case called Barnes versus Barnes. Now, the name is a little confusing, so let me make sure you understand who the real parties were. This case began with a traffic stop in Texas that went tragically wrong. A police officer pulled over Ashton Barnes for a minor toll violation. What happened next is still being disputed in courtrooms, but what we know is that the officer shot and killed Barnes during that stop. The officer claimed he felt threatened. The family argued the shooting was completely unjustified. Lower courts sided with the officer and gave him legal protection, what is called qualified immunity, meaning he could not be sued personally for what he did. But the Supreme Court looked at this case and said something very important. The lower courts got it wrong, and they said it with a 9-0 vote. Not a split decision, not a narrow majority. Every single justice agreed that the way courts evaluate police use of deadly force needs to change. Now, to understand why this matters, you need to understand what the Fifth Circuit Court of Appeals, which covers Texas and several other states, had previously ruled. That court said that when judging whether a police shooting was reasonable, judges should focus only on what was happening in the exact moment before the trigger was pulled. They called it the moment of the threat doctrine. In plain terms, they said officers can only be judged based on what they saw and felt in those few seconds, right before they decided to shoot. But Justice Elena Kagan wrote the court's opinion, and she said that is too narrow. Courts need to look at the totality of the circumstances, which means everything that led up to that moment. Why was the person pulled over? What had happened during the interaction? What context did the officer have? Kagan wrote, and this is a direct quote from the opinion, that while the situation at the precise time of the shooting will often matter most, earlier facts and circumstances may bear on how a reasonable officer would have understood and responded to later ones. The court made clear that this totality inquiry has no time limit. That phrase, no time limit, is incredibly significant. It means that if an officer had information that should have made them more cautious, they cannot ignore that simply because the shooting itself happened quickly. This decision will reshape how Fourth Amendment claims are evaluated across the country, particularly in the Second, Fourth, Fifth, and Eighth Circuits, which all previously followed the narrower moment of the threat standard. Justice Brett Kavanaugh wrote a separate opinion concurring with the main ruling. He acknowledged that traffic stops are inherently risky for officers, but he also affirmed that the full context of an encounter must be considered. His opinion was joined by Justices Thomas, Alito, and Barrett, so you had conservative and liberal justices agreeing on the same outcome, which is rare in cases involving police conduct. This tells us something important. When it comes to constitutional rights, there can be bipartisan agreement that the rules matter. The lawyer who argued this case before the Supreme Court was Nathaniel Zielinski, who at the time was with the firm Hogan Lovells and did this work pro bono, meaning for free, on behalf of the Barnes family. This was a hard-fought victory through 3 federal courts, and Ashton Barnes' mother, Janice Barnes, made clear that she intends to keep fighting for her son's constitutional rights as the case returns to the lower courts. So what does this mean for you? It means that if you or someone you know ever has a confrontation with police that leads to a civil rights lawsuit, the courts now have to look at the bigger picture, not just the final seconds. Officers cannot claim complete immunity simply because a judge signed off on a warrant, or because the shooting itself lasted only a moment. Context matters. History matters. This is a significant shift in how the legal system evaluates the balance between public safety and individual rights. Now, while this 9-0 decision was being reached on the Fourth Amendment side, the Supreme Court was also preparing to take up multiple cases involving the Second Amendment, and those cases are moving through the system right now, which means they could be decided in 2026 and change what you can legally do as a gun owner. If you are finding this breakdown useful, subscribe now and turn on notifications. We track these developments in real time, and the next update on these cases could change the entire picture of what your rights look like. Make sure you are following so you do not miss what is coming. Now let's go deeper into what is really driving these Second Amendment fights, because the stakes are enormous and the outcomes will affect tens of millions of Americans who own firearms. The first major Second Amendment case waiting for a decision is called Woolford versus Lopez. This case comes from Hawaii, and it challenges a law that makes it effectively illegal to bring a concealed firearm onto private property without getting explicit permission from the property owner. Now think about what that means in practice. Imagine you have a concealed carry permit, which in Hawaii is not easy to get in the first place. You have gone through the background checks, the training, the waiting periods, all of the legal requirements. But the moment you step onto someone else's property, even a business that is open to the public, you can be arrested for bringing your legally permitted firearm with you. The property owner can simply say no firearms allowed, and if you forget or did not know, you are now a criminal. This is what the lawsuit is challenging. The plaintiffs, who are licensed concealed carry holders in Hawaii, argue that this law violates their Second Amendment rights. They say the government cannot presumptively prohibit them from carrying firearms just because they are on someone else's property. The Supreme Court heard oral arguments in this case on January 20th, 2026. The legal question at the center is whether Hawaii's property-based restriction is constitutional. The court is examining how far states can go in regulating concealed carry after the landmark New York State Rifle and Pistol Association versus Bruin decision from 2022. That decision established that the Second Amendment protects an individual's right to carry a handgun outside the home for self-defense, and it said that courts must look to the text and history of the Constitution to evaluate gun regulations, not just balance competing interests. Hawaii's defense of its law is that it is simply respecting the rights of private property owners. The state says it is not banning carry outright, it is just saying that the property owner's preferences should control whether firearms are allowed on their premises. But the other side argues that this creates a de facto ban on carry in most public spaces, because most of the places Americans go in a typical day are owned by someone else. If every store, restaurant, park, and office building can ban firearms, then the right to carry becomes meaningless in practice, even if it still exists on paper. This case matters beyond Hawaii. Several other states have similar laws on the books, and a ruling in Woolford versus Lopez could either validate those restrictions or strike them down nationwide. For gun rights advocates, this is one of the most important cases in years. For gun control supporters, the property rights framing is seen as a reasonable middle ground that respects both Second Amendment rights and private property rights. The Supreme Court's decision in this case will likely come sometime in 2026, and it will tell us a great deal about how far the current court is willing to go in protecting the right to carry firearms outside the home. But the Second Amendment action does not stop there. Another case on the horizon is United States versus Himani, which is scheduled for oral argument on March 2nd, 2026. This case involves a federal law that prohibits firearm possession by anyone who is an unlawful user of or addicted to a controlled substance. The statute in question is 18 U.S.C. Section 922 G3, and it has been on the books for decades. But Himani's lawyers are arguing that the law as applied to him is unconstitutional. Himani was charged with possessing a firearm while using cannabis, which in his home state of Colorado is legal for recreational use. The federal government says the law does not care about state law legalization. If you are using a controlled substance, you cannot have a gun. But the circuit court that reviewed Himani's case concluded that applying this federal ban to him violated the Second Amendment, citing the Bruin framework. The Supreme Court is now going to weigh in on whether this prohibition makes sense constitutionally. The implications of this case are enormous. Millions of Americans legally use cannabis under state law, and many of them also own firearms. If the Supreme Court rules that the federal government cannot strip gun rights from people who use legal substances in legal states, that would be a massive expansion of Second Amendment protections. If the court upholds the prohibition, it means that federal law can override state-level legalization and deny gun ownership to anyone who uses cannabis, even recreationally and legally. This is also a case that intersects with criminal justice reform, because many argue that the current law disproportionately affects people of color and low-income communities who are more likely to be targeted for cannabis possession in the first place. The ACLU has filed briefs in this case, arguing that the statute is unconstitutional as applied to someone like Himani, who was a medical cannabis patient in a state where that is legal. The Supreme Court's ruling will not only affect Himani personally, but could reshape the entire landscape of gun rights for the tens of millions of Americans who use legal cannabis. Now, shifting back to the Fourth Amendment side, another case to watch is called Chattree versus United States. This one involves geofence warrants, which are a relatively new and controversial law enforcement tool. Here is how a geofence warrant works. Police want to find everyone whose cell phone was in a particular geographic area at a particular time. They go to a judge and get a warrant requiring Google or another company to turn over the location data of every device that was in that zone. The area could be as small as a building or as large as a neighborhood. The warrant essentially lets police search the movements and locations of potentially thousands of people, most of whom are not suspected of any crime. In the Chatry case, law enforcement used this technique to try to find a suspect in a bank robbery. They got a geofence warrant covering an area around the bank and obtained location data from Google. The problem, as Chatry's lawyers see it, is that this is essentially a general warrant, which the Fourth Amendment was specifically designed to prevent. You are not targeting a specific suspect. You are sweeping up information on everyone in the area and then looking for someone who matches the profile of a suspect. The Fourth Circuit Court of Appeals ruled that Chatry had no reasonable expectation of privacy in his cell phone location data, which means the warrant did not violate the Fourth Amendment. But civil liberties groups, including the Electronic Frontier Foundation and the Brennan Center for Justice, argue that this interpretation ignores the Supreme Court's earlier ruling in Carpenter v. United States, which said that accessing detailed location data from cell phones requires a warrant because that information reveals the intimate details of people's lives. The Supreme Court granted certiorari to consider whether the execution of this geofence warrant violated the Fourth Amendment. This case will likely be argued in April 2026. The outcome will determine whether police can use geofence warrants to conduct mass surveillance of everyone in an area, or whether they must get more specific warrants targeting only suspected individuals. For anyone who carries a cell phone, which is basically everyone in America, this case has direct implications for your privacy rights. If the court rules that geofence warrants are constitutional, it essentially greenlights a form of dragnet surveillance that was never contemplated when the Fourth Amendment was written. If the court says these warrants are too broad, it will force police to be more precise and targeted in how they investigate crimes using location data. Drop your thoughts in the comments below. Do you think the government should be able to sweep up location data on thousands of people to find one suspect? Does the Fourth Amendment's protection against unreasonable searches cover cell phone location information in the digital age? Your perspective helps us all understand this faster. While you are thinking about that, consider this next piece of the puzzle, because the patterns we are seeing in these cases tell us something important about where the Supreme Court is heading. Looking at the full picture of these cases, several things become clear. First, the Supreme Court, under its current composition, is taking the Second and Fourth Amendments seriously as enforceable rights, not as theoretical provisions that can be quietly overridden by government convenience. The 9-0 ruling in Barnes shows that even conservative justices like Thomas, Alito, and Barrett are willing to hold law enforcement accountable when constitutional rights are at stake. Justice Kagan, who wrote the opinion, is generally considered more liberal, but the conservative justices joined her reasoning without hesitation. This suggests that there is real constitutional principle at work here, not just partisan positioning. Second, the court seems to be moving toward more historical and textual analysis of the Constitution, which means they are asking what the text actually says and what it meant at the time it was written, rather than simply balancing interests or deferring to government arguments about public safety. This approach has generally been favorable to gun rights advocates in recent years, and it may also lead to stronger protections for digital privacy, because the Fourth Amendment's language about papers and effects can be applied to modern technology. Third, and perhaps most importantly, these cases are reaching the Supreme Court at a time when public trust in government institutions is historically low, and public concern about both crime and government overreach is high. The justices are operating in an environment where their decisions will be scrutinized, not just by legal scholars, but by millions of ordinary Americans who have strong opinions about their rights. This does not mean the court is political. It means the court is consequential. The decisions they make will affect every American's daily life, whether you own a gun or not, whether you have ever been in a confrontation with police or not. Now, let us talk about what to watch for in the coming weeks and months. If these cases follow their typical timeline, we can expect oral arguments for Wolford versus Lopez to have already happened as of January 2026, with a decision likely by June 2026. United States versus Hamani arguments are scheduled for early March 2026, with a decision likely by the end of the court's term in June or July. Chatry versus United States will be argued in April 2026, with a decision expected by late summer or early fall. And the lower court proceedings in Barnes versus Barnes will continue as the case goes back for further review, which means we may see additional developments in that case as well. Here are the 3 specific indicators to monitor this week and next. First, watch for any additional Supreme Court orders in pending cases. The court regularly issues orders and unsigned opinions that do not make headlines, but can reshape the legal landscape. Any new grants of certiorari or dismissals in Second or Fourth Amendment cases are worth noting. Second, monitor lower court decisions in cases that are working their way up to the Supreme Court. The Ninth Circuit, which covers the western United States, is currently handling several gun rights cases, and any rulings from that court will likely be appealed to the Supreme Court. Third, pay attention to what is happening in Congress and in state legislatures. The outcome of these Supreme Court cases will drive new legislative activity on both sides. If the court rules broadly in favor of gun rights, expect Democratic-controlled states to push new legislation trying to work around the ruling. If the court upholds restrictions, expect Republican-controlled states to push back with constitutional amendments and new statutes. The legal battles in courtrooms are directly connected to the political battles in capitals across the country. So where does all of this leave us? The Supreme Court has already made a historic 9-0 decision on the Fourth Amendment that changes how courts evaluate police use of force. On the Second Amendment front, cases are moving through the system that could either expand or limit your right to carry a firearm, and to possess one if you use legal substances. On digital privacy, the court is preparing to decide whether geofence warrants constitute unconstitutional general searches. Each of these cases involves a fundamental tension that has always existed in American constitutional law, the tension between collective security and individual liberty. The government has an interest in keeping people safe. Individuals have an interest in being free from government overreach. The Constitution tries to balance those interests, but every generation has to renegotiate that balance based on new circumstances, new technologies, and new understandings of what liberty means. What is happening right now is not unprecedented. The Supreme Court has always been the final arbiter of these tensions, and its decisions have always shaped the country in profound ways. But what is happening now is urgent because the cases are real, the stakes are high, and the decisions will come within months. You do not have to wait years to see how this plays out. The rulings are coming, and when they do, they will change the legal landscape for everyone. So stay informed, stay engaged, and do not assume that your rights are protected just because they are written on paper. Rights mean what courts say they mean, and right now, the Supreme Court is in the process of deciding what your rights actually mean in the real world. If you found this breakdown valuable, subscribe for our next deep dive. We are already tracking the next development, and it could change everything. The story is not over. It is just getting started.